The Constitution, as the supreme law, has incorporated customary law into the mainstream South African legal system, making it part of the law of the land. It is for this reason that all courts must apply customary law when such law is applicable in any matter before the court. Chapter 12 of the Constitution recognizes the institution, status and role of traditional leadership according to customary law, subject to the Constitution. Schedule 6 of the Constitution recognizes the existence of traditional courts. The Constitution recognizes customary law, and legislation must thus provide for it. Traditional courts exist, and therefore there's a constitutional imperative that they be transformed to suit our democratic dispensation. The Traditional Courts Bill, in its revised form, provides the desired framework which is in line with our democratic constitution. The enactment of the Traditional Courts Bill will put an end to the abuse of the system which was manipulated to serve the interests of the colonial and apartheid regimes. The envisaged legislation is aimed at transforming the traditional court system in order to ensure that these courts function under and comply with the Constitution, and in particular the Bill of Rights. Traditional courts are courts of law under customary law with the specific purpose of promoting the equitable and fair resolution of disputes. They are a center of excellence in alternative dispute resolution mechanisms and restorative justice. Their focus is on preventing conflict, maintaining harmony, and resolving disputes in a manner that promotes peace, social cohesion, and reconciliation. It is for this particular reason that the bill enjoins traditional leaders and those who guide the proceedings to take and administer a pledge to uphold the Bill of Rights. We've taken every effort to address the concerns raised in respect of the two previous bills, which were introduced into Parliament in 2008 and 2012. We have addressed concerns which were raised in relation to the role of women, the right to opt out and in, and what was perceived as an entrenchment of tribal boundaries. The main object of the bill is to create a uniform legislative framework regulating the role and functions of traditional courts in the resolution of certain disputes in accordance with constitutional imperatives and values. The bill is intended to improve access to justice, as these courts are easily accessible to local communities, to dispense justice speedily and cheaply. Although legal representation is excluded, the system allows assistance of women and other vulnerable members of society. Traditional courts must be constituted of women and men pursuant to promoting the right to equality as contemplated in Section 9 of the Constitution. The courts are required to promote and protect the representation of and participation of women as parties and members of courts. It requires the Minister of Justice and Correctional Services and the Commission for Gender Equality to put measures in place to promote gender equality in these courts and to report annually thereon to Parliament. The emphasis is on restorative justice measures, for instance, compensation and redress, which are aimed at restoring relations between parties and promoting social cohesion. We believe that the enactment of this bill will benefit millions of people who continue to lead the traditional African way of life, and equally these courts enhance access to justice for all those who choose to use the courts as an alternative vehicle to resolve disputes.